All right, we're all very dedicated coming out this morning. It must be the lure of the CLE point. I'm going to have a talk about the second half of the written offer regime, or written settlement offer regime, which is Calderbank letters. We're fairly time limited, so I'm going to have a brief chat about what Calderbank letters are and why you should send one or more. Also, briefly, a chat about the public policy behind Calderbank letters and their history, because it gives you some appreciation of the approach to Calderbank letters that the courts currently take. But the substance of what I'm going to say is the effect of Calderbank letters and the test of unreasonable rejection, which Kane referred to a few moments ago, and some hints in relation to unreasonable rejection, so time for service, drafting, what the content should be. And finally, some ancillary matters like the privileged status and a brief comparison with offers of compromise under the rules. So, firstly, what are they? Well, it's no surprise, it's a written offer to compromise litigation specified to be without prejudice, save as to costs. It's important that it's got the heading, without prejudice, save as to costs. Don't leave it off, make a precedent. You'll see why in relation to the historical development, but it's important that it has that notation somewhere and make it prominent. It should also include a reference to an application for a special costs order, and you'll all be aware of it. If your client does not beat this offer and we reserve the right to refer to it in the question of costs, yada, yada, yada. I've got a more detailed version of it later, which I don't know whether they handed the slides out. If not, they'll be available on the website, but you can pirate it from there. So there's a particular form they should be in, or particular aspects they should contain. Why do you send one? Well, we're going to concentrate on the first of two reasons, which is the prospect of a better costs outcome. So if the recipient doesn't beat the offer, there's a prospect of a more favourable costs order than you'd otherwise receive, or your client would otherwise receive. The second is you might send one to actually try and settle the matter. Now, that's a little bit peripheral today, but I'll come to it right at the end. Essentially, we're concerned today with protection on costs. Rationale of a Calderbank, obviously promotion of settlement. Now, we all know the courts are very, very keen to have matters settled rather than heard and determined. It's cheaper. At least one of the parties tends to be less irritated with the outcome, and it's a better use of resources. But there's a tension between without prejudice communication, which is what a Calderbank is in essence, and without prejudice communication should stay that way. It's to enable parties to make written offers, written comments, whatever it might be between them, in an effort to settle a proceeding that they're not worried are going to get a Guernsey before the court a little later on. And there's a tension between that and protection from disclosure and what happens with a Calderbank, which is it's without prejudice, but it ultimately gets before the court on the question of costs. And the rationale for that is having parties face up to a realistic offer of settlement. So the effect of a Calderbank is there's the offer of settlement. If you don't beat it, there's going to be the stick. It's going to bite you on costs. So that's the rationale for allowing Calderbanks to be later disclosed to the court, even though they're without prejudice communication. As I said, some history, and I'll keep it brief. But historically, if you were trying to settle something, there was only payment into court. And having a look around, I can see a few faces that remember payment into court, probably. But it was only available to defendants. If you were a defendant to a debt or damages claim, you could pay what you thought your assessment was into court. A plaintiff had 14 days to accept, and if they didn't, and ultimately didn't exceed the money paid into court, they paid the costs from there on in. But nothing available to plaintiffs, and that was as complicated as it got. You could pay money in on a debt or damages claim. And then we had Calderbank and Calderbank. Now, I've got to refer to it because it's Calderbank letters. Nobody ever reads it, but it's a matrimonial proceeding between, as you might expect, Mr and Mrs Calderbank. And Mrs Calderbank had served a without prejudice letter offering Mr Calderbank more than he ultimately got. It was a situation where Mrs Calderbank had the money and Mr Calderbank was trying to get hold of it. And ultimately it went before the Court of Appeal, and part of the appeal was on the question of costs. And curiously, given what it's come to stand for, in Calderbank and Calderbank, the Court of Appeal refused to allow the without prejudice communication to be referred to. But there was some bleating from counsel as to, well, what are we supposed to do? And Lord Justice Kane had a judicial rush of blood and produced the formula: you should be able to serve a communication that's expressed to be without prejudice to the issue as to damages, but reserving the right of the correspondent to refer to it on the issue of costs. Now, it's a bit long to put on the top of a letter, but that's where we get without prejudice save us the costs. It's from Calderbank and Calderbank, and it's from the rejection of a without prejudice offer. Just by the by, Mrs Calderbank did get her costs because she'd made the same offer in an open affidavit, but Calderbank and Calderbank essentially rejects the without prejudice but says you might want to try this. And it's sat in matrimonial proceedings for quite some time, up until Cuts and Head, and you'll have seen this on Calderbank letters in accordance with the principles in Calderbank and Calderbank, Cuts and Head, etc., etc. This is why they do it. Cuts and Head, again, Court of Appeal, but in a commercial proceeding, and again an appeal at least partly on the question of costs. And there'd been a Calderbank in the form suggested by Calderbank without prejudice that save us the costs, and again in Cuts and Head it was rejected. The court said, no, we're not going to have a look at that. And I've never seen this in another judgment, but it takes about a page to say, no, without prejudice is very important and we're not going to consider this letter. And then the Court of Appeal comes back and says, look, we've handed down the judgment, but it hasn't been entered yet. And we've become aware of a recent decision to which we weren't referred. And it appears we've all been sitting down at the club smoking cigars and drinking port and talking to other judges, and everybody seems to be at it. And given that everybody's at it, it seems like a good idea. And they take another 10 or 12 pages to say, yes, it's a good idea. So after Cuts and Head, we've got the ability to serve without prejudice, save us the costs correspondence, and have the court look at it. It's been recognised in Australia. It's all over the place. Mutual community law and holdings is one that's usually referred to. But enough of the history. What happens? If a recipient doesn't beat the offer, there's the prospect, and prospect's an important word. There's not a certainty, there's the prospect of a costs benefit. So we all know it's usually costs follow the event. If the plaintiff sues your client for $500,000 and gets $100,000, they still get their costs. As with offers of comp, the Calderbank is designed to effect this. So an unsuccessful defendant can still receive part of their costs. A successful plaintiff can receive their costs on a better basis than they would otherwise have received. But crucially, the second point in the middle, there's no presumption as to the costs outcome. There's a popular myth out there that if the other party doesn't beat the Calderbank, then you're going to get a better outcome on costs. Yeah, not true. There's no presumption. It's only a factor that may be taken into account by the court in consideration of costs. And that's the salient difference with the offer of comp procedure. The offer of comp procedure it's mechanical, as Kane said. It's set out in the rules. If this happens, then this is the consequence. Calderbank not so. Calderbank is still up to judicial discretion. I've referred to Hazeldene's chicken farm up there, partly because I like the name, but mostly because Hazeldene's chicken farm is the authority you need on Calderbanks. You needn't look at too much else, that's it. Court of Appeal in Victoria, it's the case that sets out there's no presumption as to the costs outcome, and it also sets out the crucial point, which is what the court needs to assess is whether the rejection of the offer was unreasonable at the time in all the circumstances. And that's the trick in drafting and service. You're looking at setting up an argument for unreasonable rejection. When you're drafting and sending a Calderbank, you're typically a long way from judgment. But it's important to keep in mind what its use is, and its use is before the judge, after judgment, on the question of costs. Now, unreasonable rejection. In Hazeldene's chicken farm, the Court of Appeal went through and listed a number of matters that are likely to be relevant in assessing the unreasonableness of rejection. Now, they're not exclusive, but they were enumerated by the Court of Appeal, so they're worth a look. And I've got them listed there, but I won't go through them now because I'm going to deal with them one at a time in relation to drafting and service considerations, which is the bulk of what I want to talk about. So, firstly, Stage of the proceeding at which the offer is made is one of the factors. Now, as I said a moment ago, your principal objective is to highlight the unreasonableness of the rejection. You're thinking about the costs argument at the time that you're drafting the Calderbank. So stage of the proceeding, it'll include, as I say there, state of the pleadings, discovery, experts' reports. Within reason, the earlier in the proceeding you can serve a Calderbank, the better, because the costs consequences flow from date of service, not from start of the proceeding. But if you serve one very early, you need to keep in mind that it's been very early and litigation's a moving feast. And because a Calderbank is only a fact that the court takes into account in its discretion on costs, there will be argument as to, well, look, at the time this was served, we hadn't had discovery, we didn't know our case was garbage, or whatever it might be. But beware, if you serve one early, that it is a moving feast. Again, particularly in relation to experts' reports, because often a case will turn on experts' reports. If there's a Calderbank before the experts' reports, then the experts' reports, it opens up the argument to, well, look, the complexion of the case really changed, either in relation to liability or quantum. So you can serve early, but if you do it, it's worth considering serving later as well. There's nothing stopping multiple offers. It doesn't weaken the position, and it's a good thing to do. So keep in mind, as the complexion of the case changes, it might be worth reassessing a Calderbank that you sent earlier. The one where everybody goes wrong, time allowed to consider the offer. So assessing reasonableness, the court will look at the time that was allowed to consider the offer. Everybody does 5 p.m. tomorrow or until the start of court tomorrow. Stop it. It doesn't work. I understand it's an adversarial process. You've got the client in your ear. The client says, oh, I want to make it, I want to be tough. I want to do it till tonight or tomorrow. Yeah, it's pointless. It doesn't work. With one caveat, it depends who you're dealing with. If you're serving a Calderbank on a professional litigant, an insurer, a bank, then you may do better with a short timetable. But if you're for the professional litigant against the natural person, forget it. Give them as much time as you can. 14 days is good. 14 days is the time under the offer of comp process, so it's a bit hard for anybody to argue that 14 days is not reasonable. 7's not bad, but close of business tomorrow, hopeless. More of the Hazeldean factors. Extent of the compromise offered. Again, you won't do too well with an offer to walk away bare own or an offer to forego claim for costs. I know the client likes it because it's not much of a compromise. Yeah, that's the entire point. It's not much of a compromise. So try and make it look like a reasonable compromise. Next point, recipient's prospects of success. Now, it's an interesting question because by the time these things are assessed by the court, judgment's been handed down and we're just arguing about costs. But the court is supposed to look back without the benefit of hindsight. And that dovetails with stage of the proceeding, stage of the experts' reports of discovery, whatever. We look at the recipient's prospects of success at that time. And that's why it might be useful to add what you sometimes see the detail as to the shortcomings of the recipient's case. We think we're going to win because the law is in our favour and our witnesses are all fabulous, whatever it might be. But the use of that is not merely to irritate the recipient. The use of that is to say, well, look, they were fully informed. We told them at this time how the case was going to run and what their problems were. They can't say we didn't appreciate it. That's the purpose, so that the recipient can't later say, well, look, we were in the dark at that time. Again, where people go wrong, clarity with which the terms of the offer were expressed. Now, it's a bit hard to go wrong with an offer of comp under the rules because typically an offer of comp under the rules involves, say, consent to an injunction or an offer to pay a specific amount of money. But sometimes people want to serve a Calderbank because it's a little bit rubbery, it's a little bit different. It's not something that fits within the offer of compromise procedure. And that can be a problem because we end up with very complex terms. And of course it only happens on the instructions of the client, and you suggest to the client that we serve a Calderbank, and the client said, oh yeah, but I want I want them to release somebody else and do some work for somebody else, and I want to pay them 10 grand now and 5 grand next month, and it all gets very, very hard. The offer needs to be something that is reasonably easily assessed and something that's capable of acceptance. You'll see Calderbanks which essentially are a bit of a chat and are an invitation to treat. They need somebody to come back in relation to, for example, assessment of the value of property. It should be a complete offer, as the name suggests. It should be complete, ready for somebody to say, yep, okay, we'll do that. And if somebody says, yes, we'll do that, it should be clear what it is that's going to be done. So time for payment should be clear. It should be in a final form that just needs somebody to say yes, and it needs to be easy to assess. I don't know about this as a factor, but the Court of Appeal thinks it is one. Whether the offer foreshadowed an application for a special costs order, and I said I'd include that, it should be some version of that. Should your client not accept the offer and at trial obtain a judgment not all favourable in the terms of this offer, our client will produce this letter to the court and seek an order for costs on an indemnity basis in accordance with the principles set out in blah, blah, blah. As I said, make a precedent. Make sure it's got without prejudice, save us the costs at the top. Make sure it's got that in the concluding paragraph. Because it's very, very embarrassing if you've got a Calderbank that's almost there. So it's okay, say, on quantum, and then it's missed one of the factors that the Court of Appeal thinks important. So there's argument, and your client is rubbing his or her hands together and thinking, yeah, we're going to get a favourable cost order. No, we're not, because of a defect in the drafting of the Calderbank. So even though they're correspondence and there's a tendency to treat them like you would any letter to the other side, there are formal matters that you should take into consideration. Now, this is not one of the Court of Appeal factors, but something I've alluded to a few times. You need to consider the eventual assessment by the court as to whether the recipient's beaten the offer. And that dovetails with what I was saying before about complexity. People serve Calderbanks because they want some sort of complex deal. And if you've got a complex deal that relates to long terms for payment or that relates to confidentiality, for example, you're never going to get confidentiality in a judgment. So many people want to put a term for confidentiality in a Calderbank letter. It's just a fertile ground for the other side to say, well, we don't know whether they've beaten it or not. We'd never have given them confidentiality. Involvement of non-parties. It does happen. If you've got a complex deal, we'll settle it on the ground that you do various things with other people who aren't... It just gets too hard. Now, it might be useful in terms of settlement negotiation, but it's unlikely to be useful in terms of costs protection. So have a think about what sort of judgment might reasonably be obtained and draft accordingly. And the usual bugbear, costs to the date of offer. Now, Kane referred to this. One of the reasons that people prefer a Calderbank is an offer of comp is by its nature plus costs, according to the rules, like Victorian State Court rules anyway. And nobody wants to do plus costs because plus costs is uncertain. You draft it, you can say plus costs on a party-party basis to be taxed in default of agreement, but then we just end up in a barney about costs and bills of costs and time before the costs court. So people want to do all-in offers. If you're doing an all-in offer, make a reasonable allowance for costs, because that's what we're doing at the end when we're having a costs argument. If somebody's received a particular quantum, call it 100 grand, you then go to the question of, well, what would the party-party costs up to that date have been? So for a plaintiff. And there's a rule of thumb assessment, and if it gets too hard, a judge doesn't want to do it. A judge has heard however many days of trial you've had, they've gone away for God knows how long to produce a judgment, they're sick of the facts, they're sick of the parties, they just want to move on. Then we've got the costs argument, and if it gets too hard, it's much, much easier if you're sitting at the front of the court to say, no, too hard, I can't see whether this would have been unreasonable rejection or not, it's not clear to me. If it's not clear to me, it wouldn't have been clear to the parties, that's it, let's move on. It's an easy road. So you need to make an allowance for costs, and it needs to be a generous one if you're not going to do plus costs on a party-party basis. Ideally, it should be plus costs. The client won't want to do it, but ideally, if what you're aiming for is protection on costs at the end of the day, even a Calderbank should be on a plus costs basis. Yep.
To show what's reasonable allowance, do you need material instead of from the bar table, material from a cost consultant or an affidavit at that stage? How far do you have to go?
But typically nobody's going to look. The costs argument, unless it's something that's run in the Supreme for 20 days, the costs argument is going to be fairly brief. It's going to take half an hour tops before the judge on the handing down of judgment. Now, I find for the plaintiff, I publish my reasons. Okay, here we go, we have the costs fight. So it needs to be something that's reasonably easily defensible at that point. So if you can say, well, look, at that point, we didn't have the experts, we didn't have this, all we had was a certain amount of preparation and some pleadings. We've allowed 10 grand, that's got to be right. It's a defensible figure on the fly, if you like. If it were a much longer proceeding and a much greater amount of costs, then you'd go down the road of dotting all the I's and crossing all the T's. The least palatable point's the last one for the client. You should offer to pay the most or accept the least which the client can live with. Now, nobody wants to do that early. Everybody believes in their case until they've paid a large amount of legal costs, or until they're at mediation or wherever it might be. But if you're looking for protection on costs, ideally a Calderbank should be such that if it's accepted, your client sucks air in through their teeth and thinks, geez, I wish I hadn't done that. So it's like a mediation. The appropriate offer is one that makes either side equally unhappy. If a Calderbank that you're sending is something the client is happy about, oh yeah, no worries, I can live with that, it's not going to work. It's not going to be a realistic estimate unless the other side completely fails. So given what you're doing, seeking protection on costs, the time for taking instructions on a Calderbank is the time to bite the bullet and be tough with the client and pay the most, accept the least that the client can live with. Once you've done it, you've done it. It's open for 14 days. The other side haven't accepted. You think, yep, beauty. You can go to subsequent mediation and say, well, we've made the Calderbank. You're at risk. It's a good, generous Calderbank. We're not going there again. You only have to do it once. You might be unpopular with the client if the other side accepts. But as I said, that's a good measure of quantum. If the other side accepts and the client's not devastatingly unhappy, but less than thrilled, that's probably a good pitch. So a few ancillary matters, and I referred to this earlier. Calderbank letters are, by their nature, privileged. They're a unique exception to without prejudice communication in that the court can ultimately have regard to them on the question of costs. But until we're talking the question of costs, they are privileged, and I've provided some references to the Evidence Act, but it's not a controversial point. What's not always realised is the privilege attaches to both sender and recipient. You tend to think, well, we've made the offer, it's our privilege. No, without prejudice privilege or settlement negotiation privilege is both sides. So unless you have the consent of both sides, there shouldn't be reference to it. So stop putting them as exhibits to affidavits. You see it quite a bit. On the 29th of April, we offered to settle a proceeding and here's a copy. Yeah, don't do that. So they remain inadmissible, save for the ultimate argument on the question of costs. Now, I said at the start, you send a Calderbank for one of two reasons. One being protection on costs, which is where I've spent the time so far, and the other in relation to the promotion of settlement. And sometimes you do it actually to try and settle the thing, and different considerations apply. For a start, we can forget what I just said about making the offer the most or the least that the client can stand, because you're in the negotiating process at this stage. But it's as well that in your own mind you don't get confused about what you're doing. If you're sending a Calderbank for settlement purposes, the considerations are different, and don't assume the costs protection is going to be there. What you're doing is trying to get a dialogue going, obviously. And you can have complex terms. You want to leave some wriggle room in relation to amounts you're offering to either pay or to take. So it can be used for that purpose, but don't be confused and think, oh, well, we've sent a Calderbank, so yeah, that's good. Keep in mind what you're actually drafting the document for. For settlement, it's to get the negotiating process going. For protection on costs, you're thinking about what the judge is going to be thinking 6, 12, 18 months up the track after judgment on the question of costs. Finally, and Kane's referred to this as well in passing, Calderbank offer compared to offer of comp. Now, there was a recent article in the Law Institute Journal, as Kane said, and there were some surveys, and it appears that practitioners are more inclined to send an offer of comp than, a Calderbank than an offer of comp. And it's a bit unclear as to why this is. I think the costs question is probably the most fundamental, that you can do an offer of comp. You can do a Calderbank all in, but you can't with an offer of comp. It might be fashion. You might just feel better about drafting your own Calderbank rather than an offer of comp. But at a working minimum, think about it. The beauty of the offer of comp under the rules is certainty. The rules always say, unless the court otherwise orders, but effectively it's as night follows day. If you follow the procedure under Order 26, if it's expressed to be in accordance with the order, if it ticks all the boxes, then the costs consequences will automatically flow. And Justice Croft aside, typically the costs consequences will be applied in the absence of something out of left field. As Kane said, something like very late discovery, a very late change in the complexion of the case. That's unless the court otherwise orders. But usually, tick the boxes, get the consequence. That's why you do an offer of comp. You don't want to be facing a well-informed client who wants to know why you did a Calderbank rather than offer of comp. Have a think about why you're doing one rather than the other. And if there is no reason for a Calderbank, serve an offer of comp. It might be that in a Calderbank, a historical change. It used to be that offers of comp were solicitor client costs, but everything's indemnity costs now, so there's no benefit of a Calderbank on that basis. So it might be the costs. It might be that there's something unusual. If there's something unusual, you start to get into problems as to whether the court can assess whether you've beaten the Calderbank or not. So if it fits, do it as an offer of comp is my advice. Yeah.
Isn't one of the advantages of the Calderbank in this context that you can serve Calderbank offer private litigation? You can serve the Calderbank private litigation, but you can't do a compromise until
the time limit is useful, yeah. An offer of comp must be open for 14 days. Recipient for an offer of comp has 14 days to accept it. If there's no time limit specified, it must be open for 14 days. Calderbank, you can do less. 7 days, 3 days. As I said earlier, though, beware of until the commencement of proceedings tomorrow. So that's one of the reasons. You've let it run. You've got 11 days to trial. You might think about a Calderbank.
Sorry, yes, but my concern was that you can serve a Calderbank offer prior to litigation, whereas an offer of compromise, it can't be served until the litigation's on foot.
Yeah, that's true. And even more so now that we're under the regime of the Civil Procedure Act, and it's very clear that what everybody should be trying to do is bring the litigation to an end. And it's a good point. I should encourage that. A Calderbank's a good thing to do at the start. You can do it with a draft statement of claim. Look, this is what we propose filing. Here's the Calderbank. Have a good think about it. That's a good idea. And there's no issue with the Calderbank being before litigation, whereas, as you say, an offer of comp is during the course of a proceeding, just by its very nature. So the Calderbank, you get some flexibility, but you don't get the protection. All you get is consideration on the question of, was its rejection unreasonable at the time? And that's the mantra to keep in mind. How do I make it look as if they don't accept this, that it's unreasonable? And other than questions, we've rattled through and that's it.
Chris, you were talking earlier about the importance of clarity of the terms of the offer in the letter. If you were to draft something so that the terms are clear, so for the amount and the time for payment, but you make it subject to the parties entering written terms and appropriate release, would that potentially arguably reduce the clarity of the offer at that point?
Yeah,
particularly if... Sorry?
Yeah, it certainly would.
It would, okay.
And it depends. Just considering whether I should say this or not, but there's a degree of difference, it seems to me, in my experience of the assessment of these offers, depending on whether they're served by a plaintiff or an institutional defendant. An offer of or a Calderbank, I should say, that's served by a natural person plaintiff is going to get an easier run, I'd suggest. So if you're serving an offer of comp by the insurer defendant, I'd be careful of providing any avenue for argument that it shouldn't apply. Okay. Because courts are reluctant to award indemnity costs against natural person plaintiffs. Mr. McKenzie, got a hard one?
Chris, I was just interested on the question of the way costs are now assessed. You talk party and indemnity. Now there's a slightly different regime.
Standard
we'll
basis.
Have some going back to somewhere, and then we've got reasonable costs instead of those other categories. How does that affect what you might say?
Who knows? It's the new costs basis in the Supreme, according to the practice note. There'll be costs on a standard basis, which seems to be somewhere, it's either the old solicitor client or it's very close to it, as opposed to parties. I don't know. If you're putting the phrase in a Calderbank in the Supreme, you'd have to say plus costs on the standard basis. But currently it's only the Supreme, as I understand it. The county, the Maggies, is still party, and VCAT still does costs on whatever basis the county court thinks costs should be on. So it's a thing to keep in mind with the Supreme. We're now talking costs on a standard rather than, inverted commas, party basis. Yeah.
For a Calderbank that's only open for 24 hours or so, that may be unreasonable. If that's expressly not accepted within that time, can they then not argue that later down the track that it was unreasonable, the amount of time?
Done that. It's a ground of argument. Yes, you say, look, the test is, Your Honour, whether they had time to consider it. Clearly they had time to consider it because they rejected it. It's implicit. And if you're acting for an insurer, they'll say, no, go away. And if you're acting for a plaintiff, it might work. Yeah.
A question for Kane. What about acknowledgement of receipt? I'll often serve Office of Compromise and don't get acknowledgement of receipt.
Sorry, I actually thought after I finished that I should have mentioned that. You must acknowledge under the rules within 3 days, acknowledgement of receipt. That's required under Order 26. And I haven't turned my mind to the consequences of not acknowledging, but it's certainly prescribed in the rules that you have to do that.
Can I just ask a question generally? What's the concept of beating an offer? Say you offer $10,000, but the court makes a pronouncement with interest. Who's beating whom?
You should, in my view, assess interest that the court would have awarded to the date of the offer of comp. The rules provide for, and I can't remember whether it's exceed or equal. The rules are quite precise as to what beat means. In terms of a Calderbank, it's a bit more rubbery, whether equal means beat. But you would assess, you should assess interest to the date. We're done. Thank you. One more.
In a particular circumstance such as retail tenancies down at VCAT, when there's a specific legislative rule that says no one gets costs, does the offer trump that? And similarly with TFMs, where it says the estate will bear most costs unless it was an unreasonable claim, are there other rules and cautions we need?
Two separate questions. VCAT is a different beast because VCAT is supposed to be a bare own costs jurisdiction unless, and I can't remember which provision of the VCAT Act it is, but there are the criteria set out. There's also a specific VCAT written office procedure, and if you follow that, set costs consequences apply. But a Calderbank in VCAT, it seems to me, provides one of the criteria that you can deal with in the tribunal, saying, well, yeah, I know it's a bare own costs, but we served the Calderbank and this is one of the factors you should have taken into consideration. I think typically they will, but you're only going to get parties in VCAT at the best of times. In terms of TFM, I reckon TFM is got to be the poster area for a good Calderbank, because typically you can run the most speculative claim, you can lose, and the costs will come out of the estate, and it frustrates everybody. So TFM is a very good place to lodge a decent Calderbank so that you can at least lean on the judge. Thank you.
Well, thank you all for coming and bearing and weathering the storm that's out there. Thank you all for coming, and I think there's still a little bit of food left at the back there if you want to try and grab some on your way out. Thank you.